Hey everyone, it's Rob Ryder on Sunday, July 22nd, 2018. Today, motion, remedial sanction. Well, what could that mean? Well, first of all, what's a sanction? It's that part of the law which inflicts a penalty for its violation or bestows a reward for its observance. Sanctions are of two kinds: those which redress civil injuries, called civil sanctions, and those that punish crimes called penal sanctions. Well, we're going to figure out what that is eventually. Hey, I'm Rob Ryder, and my email address is courtofrecord@aol.com. That's COURTOFRECORD, no S's, at AOL.com. And that's the way to get a hold of me. I don't read comments and so forth. There's just too many different places that if I said, well, I'm going to go check those, I would always be checking to see what people have written. If you want to write me, it had to be at courtofrecord@aol.com. And I would be dishonest to say that I answer all of them, although I would like to. I just don't have enough time. My phone is 616-712-6179. What the heck happened here? Okay. Donate if you can, please. PayPal would be robryder@aol.com. I can send you a request or an invoice if you don't have a PayPal account. I do believe. And you could use a money order or, electronic check, credit card, debit card, or you can send it regular mail. Robert Allen Rutluski, 10955, 14 Mile Road Northeast, Rockford, Michigan, 49341-8664. And thank you to all that have donated in the past. Thank you, thank you, thank you. And a developing storyline is this fact that if you go to Dunn's and you put in a certain phone number, for me it was 616-456-2963, it comes up Superior Court, or Supreme Court, United States. In fact, this is the way the heading would come up. And it's in a particular room. We'll look more at that in just a second. I wanted to give you the definition of the day, which would be collusion. You hear a lot about collusion these days, and the Russians are collusion and so forth. And well, what does that mean? It means in law, a deceitful agreement or compact between two or more persons for the one party to bring an action against the other for some evil purpose as to defraud a third person of his right. Almost sounds like a foreclosure. Or a secret understanding between two parties who plead or proceed fraudulently against each other to the prejudice of a third person. Well, that would be the Democratic Party and the Republican Party in collusion with each other against the rest of us that aren't Republican or Democrat. Call us independents, nonpartisan, take your pick. The truth of the matter is the Democrats and Republicans are the same party. They split the Democrat-Republican Party in like 1803 or 1805 into two different factions, but it started as one party. That's the way the system works. They start with one and they split it, and then they split it, and then they split it. And pretty soon you have one becoming many, 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 and you have to do all these parts to get back to the one. Well, in this particular case, this was the first split in 1803, I think it was, again, where they took the Democrat-Republican Party, or it was the Republican-Democrat Party, not really sure, split it in half and became the Democrats and Republicans. Well, that would be collusion, because they're really the same people, just two sides of the same coin. Okay, so let's take care of some of these other things first. What's this about the Supreme Court? Because this is going to be very, very telling and useful information, I do believe. So there it is, right? You go in and put in a phone number in Dunn's. Again, this is Dun & Bradstreet. Dunn's number lookup. If you put phone numbers in, certain things pop up. And what that number really goes to, is the thing we would call the Western District of Michigan, United States Bankruptcy Court. But that isn't what they told Dunn's, because in Dunn's, to get a Dunn's number, they had to give the legal name. And so they called it Supreme Court, United States. Well, that to me is sort of like Rutluski, Robert Allen, which they do that also some places, like on Duns. It's funny though, on one page of Duns it doesn't. I believe this one wouldn't show my name backwards, but another Duns I've shown does. Nevertheless. So you could say then, well, if that's the same thing, I don't say I'm Rutluski, Robert Allen. I say I'm Robert Allen Rutluski. So this is United States Supreme Court. Well, how could that be? It's the Bankruptcy Court. Well, in the Bankruptcy Judges Act of some time at some date, we'll look at that in a second, but now it's in United States Code 28, United States Code 152, where it says the United States Court of Appeals for the circuit shall appoint bankruptcy judges for the judicial districts established in paragraph 2 and such numbers as are established in such paragraph. Such appointments shall be made after considering the recommendations of the judicial conference submitted pursuant to subsection B. Each bankruptcy judge shall be appointed for a term of 14 years, subject to the provisions of Section E. And now the important part. Bankruptcy judges shall serve, shall serve as judicial officers of the United States lowercase district court established under Article 3 of the Constitution. So the bankruptcy judges are Article 3 judges, or they're at least Article 3 judicial officers of a Article 3 court. And that could be handy to know and to use because they have such things like, what would I be looking for here? Oh, we need to go look at some laws now. So, what does it mean to be Article 3? The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time be ordained or established. Well, what did they call themselves? Again, this is Duns, man. They had to give their full legal name to get a Duns number. And so they say they're the Supreme Court. That would be this Article 3 Supreme Court we're talking about now. Right? The judicial power shall extend to all cases in law and equity, comma, arising under the Constitution, comma, the laws of the United States, comma, the treaties made, comma, or shall be made, comma, under their authority, semicolon. Well, basically, if you have a bunch of things under commas, you can take them out, right? So the judicial power shall extend to all cases under this Constitution. Shall extend to all cases the laws of the United States, treaties. And it goes on and on. Let's just say that they have the authority under this Article 3 and extends to all cases in law and equity. So while they may not be the judge of the Article 3 court, they're at least the magistrate of the Article 3 court. Well, there's a law. Since they said laws, well, the United States Code is a law of the United States, and it says in 18 U.S. Code, United States Code, USC 3041, power of courts and magistrates, for any offense against the United States. For what? Well, for any offense against the United States, the offender may, by any judge or judge of the United States, well, who would they be? Well, those would be the people under Article 3. Hey, that's the bankruptcy judges, according to the code. 28, United States Code 152. Bankruptcy judges shall serve as judicial officers of the United States District Court established under Article 3 of the Constitution. So I'm quite sure that, by the time I talk to you again, I'll have sent them something to see what they can do. Try to give them something to do. But this isn't really why we're here today. I just pointed it out because it's something that, like I said, it's a developing storyline. So, why are we here? Well, I was doing, in my last video, which was As the Lord Lives, as the Lord lives, my last video, you would have seen this court case, Rock County case number 2018 CV 000136, Ditech Financial LLC versus Terry L. Wilson et al. And we had tried putting in a UCC filing, a financial statement. Talked about that in the video. And another one, which is on the same form, but you check a box. Well, now it's a non-UCC filing. We put them in this court case. Well, since last we spoke, there's been lots of action. I think this is where we were, right? They put, so on 7-5, I think when we last spoke, it was it 628? No, it must have been after that. Must have been after 7-5. These had been put in. Hadn't seen these yet. These were things put in by the attorney firm. And you can find this online yourself. You just go to, Google Wisconsin Circuit Court cases. You'll find the thing, do whatever it says, go to Circuit Court and put Wilson in as the surname and Terry, T-E-R-I, as the first name, and look for the thing happening in Rock County. And that's what this is. So these had gone in, all sorts of paper had gone in. Hadn't seen him yet because Terry hadn't had a chance to get down there. And then on 7/16, Terry's paperwork shows up. 7/16, 7/18. See all this paperwork going on? 7/18, petitions go in. I wanted to show something. These certified copy of Liz Pendens. Certified copy of Liz Pendens. Now, Liz Pendens, by definition, is a suit pending. What those are, though, when we go look at them, is they're copies of name registrations. They call them firm name registrations, I think, in Wisconsin. The DBA, the assumed name certificate, whatever it is, right? The fake name certificate that we had done with the register of deeds first and then filed into this court case. And when they filed them in, the court calls them certified copy of Liz Pendens. But then soon after that then comes, on the same day, a letter from Attorney Forshag, petition and order to direct Wisconsin Department of Financial Institutions to expunge defendants' 528 and 629 financial statements from official records. Well, that's interesting. The attorney, he's trying to have what we put in removed from the records. Now, in Michigan, to do this, he would have to file a fraudulent filing affidavit to say, hey, it's, the financial paperwork is fraud. Had some exhibits attached to it, exhibit. And then a petition directing the Department of Financing Institutions to expunge. Hey, I think he's already talked about that. So he wrote a letter about it. He wrote a petition about it. All those things happen, and, well, then there's this last one, which would have been, I believe that would have been Friday. Ex parte motion, remedial sanctions, filed by Terry Wilson. Wow. Now, the problem with, this is, while it's interesting, it doesn't really show you anything. So what we'll do now is we'll go look at all these documents that had something to do with getting this case to this point. And, well, it's not like watching somebody's home movies, right? I just can show you slides and then tell you what the slides are. I don't even know if they have in the particular order they need to be, right? But they all have something to do with this. Or another one we're going to look at is a non-judicial foreclosure in Georgia. And there's things in that we're going to talk about have to do with that. But mainly what we're going to talk about are the different pieces of paper that have been filed into this case, or not even filed in the case, but had something to do with this case ever since we started putting in a UCC, Uniform Commercial Code 1, which is, they call them a financial statement. And but as I said, if you look on the form, it's got a place to check a box that says, well, now it's non-UCC. Well, then it's not a financial statement. Well, what is it then? Well, when you file it with the state, what it's going to end up becoming is a state record, right? In the official records. This attorney knows this. That UCC is in the official records. So I think by the time we're done, what we're going to see is, well, real soon, this judge is going to make a decision siding with the attorney or with Terry and her latest motion for remedial sanctions. So, okay, where do we need to go next? I got lots of things to look at. This could take quite some time. Okay, so let's just start here, because this is going to be kind of the same for anybody in a foreclosure. Right, when you start getting mail, now this isn't like the first letter in this, it's just another letter in the process of things that Terry had gotten in this court case from this Gray and Associates, which claims to be attorneys at law. Keep that in mind. And it says Gray and Associates LLP is attempting to collect a debt. Oh, they're a debt collector, right? That's what they're acting at. They're acting as a debt collector. Now, everybody's going to want to run to go get a Debt Collection Practice Act letter and all these other things from these people. And okay, well, what is, before we do anything, let's go and see what you need to do to be a debt collector. Here, it's under collection agencies. Page 31. Right, so all this is based on Wisconsin law. You're going to have to go find your own law to find it, but it all, they're not that much different. Collection agencies. Collection agency means any person engaging in business of collecting or receiving for payment for others, or any account, bill, or indebtedness, or of any account, bill, or indebtedness. Collection agencies does not include attorneys at law authorized to practice in the state and resident therein. Okay, so if you meet the criteria as that attorney, well, then you don't, then this doesn't apply to you. But if you didn't, well, you'd have to have a license. Applications for licenses under the provisions of this section shall be made to the division in writing under oath on a form to be prescribed by the division. All licenses shall expire on June 30 next filing, date of issue, except as provided in 3, as an application for license under this section shall include the following, blah, blah, blah. Okay, well, we'd say, okay, well, that the attorneys don't have to do that because, hey, they're attorneys at law. They said so. It's at the top of their freaking paper. So I closing some of those out. Let's see. So where did that say that? Where am I hiding all those things? All right, so here's the letter again. Just so there's no question what we're talking about. We're talking about people saying they're collecting debts, and because these people say they're attorneys at law, they may have said attorney at law on the other one. I have to go look again, right? Because, are attorneys at law the same as attorney at law? I don't know. But what this is this is a LLP. This is a entity that's been registered with the state as a limited liability partnership of attorneys at law. Okay, and where would that take us? So I'm not here babbling to myself as I try to remember where I put everything. Give me just 1 second. Okie dokie. So, again, what we're going to do, since these people say they're attorneys at law, and they're trying to collect a debt, and the debt collection law says, well, if you're an attorney at law, you don't have to have a license from us, right? But Gray and Associates is a limited liability partnership of attorneys at law. Well, there may be something to do with them. And as it turns out, hey, they have their own stuff. And so I can't say every, but I will. Every state is going to have some sort of rules of professional conduct for attorneys. The Supreme Court of your state is going to have superintending control over the practice of law, and under the Supreme Court will be the state bar of the state, and then the Supreme Court rules, right? SCR, Supreme Court Rules, Chapter 20, Rules of Professional Conduct for Attorneys. And because it's kind of hard for me to work with this, I'm going to go to this one instead, which this is the rule then that's in that book. It's Supreme Court Rule 25.7, Limited Liability Practice, where it says a lawyer may be a member of a law firm that is organized as a limited liability organization solely to render professional legal services under the laws of this state, including these chapters of whatever. The lawyer may practice in or as a limited partner organization, right? So the lawyer can do it as himself or as the business and still say it's attorney at law. The limited liability organization actually gets to practice law. If the lawyer is otherwise authorized to practice law in this state and the organization is registered under sub B. Nothing in this rule or laws under which the lawyer or law firm is organized shall relieve a lawyer from personal liability of any acts, errors, or omissions of the lawyer arising out of the performance of professional services. So, a lawyer or law firm that is organized as a limited liability organization. Now, how could a lawyer be organized as a limited liability organization? Well, I saw in New York that when they're using their middle initial name, if you put that into DUNS, the middle initial name of an attorney, I can't say it's all attorneys, but these were ones involved in a child issue, domestic law, that they came up listed in DUNS. Like Robert A. Rutlewski, if I put that in, boom, it would come up with an address, and there you are, right? So I guess that's how they could do it. Or it could be a law firm where now it's Gray and Associates, LLP. Either way, organized as a limited liability organization shall file an annual registration with the State Bar of Wisconsin in a form and with a filing fee that shall be determined by the State Bar. The annual registration shall be signed by the lawyer who is licensed to practice law in this state and who holds an ownership interest in the organization seeking to register under this rule. The annual registration shall include the following: name and address of the organization's names, residence addresses, states, jurisdictions, where licensed to practice, and notary registration numbers of the lawyers in the organization, their ownership interest, representation that at the time of the filing, each lawyer in the organization is in good standing of the state, certificate of insurance, insured by an insurance carrier certified that it is issued from the organization a professional liability policy to the organization as provided in BM. Professional liability policy shall identify the name of the professional liability carrier. Right? So, hey, this is where their insurance is. Depending on the number of attorneys, well, they got to have a higher amount. Okay, da-da-da-da-da. Good. What does that mean to us? Well, let's get down to what it means to us. So then, what I did, I said, well, they're not going to have a license, right? Because they say that they're attorneys. So I'm going to ask these people. I'll just email the state bar. Come on, freaking thing. And so I did last Saturday, right? Rob Ryder, hey, that would be me, to administration customer service mailbox. Who did I get a hold of? Well, customer service. Subject, SCR, Supreme Court Rule 25.7. Limited liability legal practice. Written request for current registration information provided the State Bar of Wisconsin in accordance with SCR 25.7, limited liability legal practice for Gray and Associates LLP. Their address, regards, myself. And, I didn't write much because I really didn't expect them to answer. But they did. And they seemed to me they answered pretty dang quickly. Like, by 9:15 a.m. on Monday, I sent it on Saturday. So within 15 minutes of, 9 a.m. starting to work, they're sending me an answer. Please see attached. Further requested limited liability practice registration form for Gary or Gray and Associates. Let me know if you have any other questions. Well, that was handy. What did they send me? They sent me a 2-page thing that came from the State Bar of Wisconsin, May 22nd, 2018. Now, again, I just did this, on the 14th of July, and they're sending me something from May 22nd. Attorney Duncan C. Deli. He's, as it turns out, he is the registered agent for Gray and Associates. Dear Attorney, ATTY, this letter is to remind you of the important legal requirement for your firm, which our records list as a registered limited liability practice, limited liability company, or service corporation. Law firms, as well as lawyers, practicing in Wisconsin must renew their registration annually with the State Bar of Wisconsin, as specified in Supreme Court Rule 2520:5:7. Your registration expires on June 30, 2018. We have tried to make renewal process as simple as inconvenient as possible. Renewing your firm's registration requires 3 things: completion of the form, registration fee, proof of adequate malpractice insurance. To satisfy requirement 3, please submit either a current certificate of insurance or a binder page indicating your level of malpractice insurance. If you have any questions, hey, give us a call. So this is what she sent me, which, as you can see, is blank. Registration form for year ending June 30, 2019. Now, I don't know if she's saying up here that, hey, you were registered, right? Your registration expires on June 30, 2018. Well, that's just the yearly time that it expires. So did they return this to her? Because here now we have attorneys using middle initial names, giving a particular address, residential address, not residence address, residential address, the address in the residence. As it turns out, your residence address, that's more like your township hall or city hall or whatever your municipality is. Another developing story as we go. But what these people would have to do now, they'd have to have filled this out and put in the state or jurisdiction where licensed, right? Where are they licensed in this name? They're not licensed in this name anywhere. They may be licensed in their full legal name, or at least had signed the roll of attorneys for the state, but it ain't in a middle initial name. Got to put down their nature of ownership, and somebody had to sign it. Well, if they didn't do this, they would be in contempt of the Supreme Court, right? Because they don't have a license or didn't have to have a license as a debt collector, because they're attorneys at law. But to be an attorney at law and have a limited liability practice, either as an attorney or a business, you have to have registered with the State Bar of Wisconsin, which is under the Wisconsin Supreme Court. And so the evidence is coming, from an agency of the Supreme Court that says either they do or they don't have this. And so because we have a court case to work with in Terry's case, we put it into the court case. But I think if you didn't, you could just take this now. You would have something to take to the attorney review board or whatever they call it for your state, which I know a lot of people have used and nothing's happened. I'm one of them. But I didn't have this information before. I'd go try it again and say, hey, these people don't have a frickin' registration according to your rules. Or according to the state bar of Wisconsin rules. So according to the state or the Supreme Court of Wisconsin rules. All right, so look into it. I might be doing that next week too. So that was, that was where we ended the day. But there were some things that happened before that. But this was the idea that, hey, let's write up something and put it in based on this and say that they're in contempt of court, which is what they were. And in Wisconsin, under contempt of court, it says, remedial sanctions means sanctions imposed for the purpose of terminating a continuing contempt of court. Power court to punish. So you got a couple different ones. You got punitive sanctions, right? And you had remedial. Punitive means a sanction imposed to punish a past contempt of court for the purpose of upholding the authority of the court. So let's look a little closer at these because we took A to start with, right? Remedial sanction. A person aggrieved by a contempt of court may seek imposition of a remedial sanction for the contempt by filing a motion for that purpose in the proceeding to which the contempt is related. The court, after notice and hearing, may impose a remedial sanction authorized by this chapter. Now, the court is the judge, and we put it into the court case, but I may tell Terry to fax a copy to the judge's office on Monday just so they can't say they don't have it. They should have gotten it, but you know how these things work. Punitive sanction. Now, this is punitive. The district attorney of the county, the attorney general, or special prosecutor appointed by the court may seek the imposition of punitive sanctions by issuing complaint charging a person with contempt of court and reciting the sanctions sought to be imposed. So if you didn't have a court case, you could take it to the district attorney, the attorney general, or the special prosecutor appointed by the court. And I believe the special prosecutor appointed by the court is the attorney review board or the attorney discipline board or whoever they are, right? So you could take it to them, you could take it to your county. You should be able to take it to any of them. First, get a hold of the state bar and ask for, first, go look at your rules, see what it says about limited partnership. Let me make sure I get the name right. Right, limited liability legal practice. They had to register, ask for the registration form. If you get a blank one like I got, well then start complaining, right? And then either they're going to prove it, that they have one, or they're in contempt of court. All right, that'll be an interesting day. I mean, Monday could be really interesting. Hey, that's tomorrow. Wow, we're getting really close. Tick, tick, tick goes the clock. Okay, don't need that, don't need that, don't need that. So again, give me just 1 minute to get my thoughts together. Okay. Just to review, I showed these in my last video, As the Lord Lives. These were the two financing statements we put into Terry's case. In fact, this first one I sent to sent acknowledgement to the Office of the Attorney General. I really didn't know what to do with the acknowledgement, but well, now I understand better. Although they say in Wisconsin they don't give you a separate acknowledgement, that everything you need is already on this form. In Michigan, they send you a separate form to put to the front of this filed UCC to show that it's been actually filed with the state. It's an acknowledgement from the state that it was filed with the state. Not you just walking in with a form that says that you did it. No, you get this acknowledgement to put on the front. Well, they won't give that to you in Wisconsin for some reason. Nevertheless, what did we do? Well, we found the headquarters address for state of Wisconsin on Dunn's, right? D&B. Start putting in people's names, their phone numbers. When I put in that case, when I put in the phone number for the governor, it came up State of Michigan headquarters. I don't remember how I found it for Wisconsin, to be quite honest. I just know that I did. And so I put them down, right? And when you find them, they have a particular address. So whatever the address is, however the name showed up, is I put them in. Well, I took a phone number from the courts of Rock County and started putting them in, and boom, up comes Judiciary Courts of the state of Wisconsin. Boom, I'm going to make them a debtor. All right, that's the address of the court building. And, Gray and Associates, LLP, I put them into Dunn's, and they came up. So I made them all debtors. Made the government of the United States, which has its own address, and Terry Lynn Wilson, her own address. And we did her as an organization because Terry had gotten an EIN at that time as a sole proprietor. Another thing I've talked about in videos for some time, but if you went back to like December of 2017, you would see a video called EIN and SSN in your own name, and I'm showing how to get an EIN number as a sole proprietor in your own name. Right? Not as an estate, no additions, no, just Terry Lynn Wilson, sole proprietor. You do it as a sole proprietor. If you go watch that video, don't use the form I'm showing on the video. You can go directly to the IRS website and do it. And when you're done, 10 minutes or so it's going to take you to do it. They're going to send you an SS4 completed that has an EIN number on it. Now, for the sake of the time and not knowing the difference and still not really sure, I used my mailing address, as I would call it, for the residence address and for the mailing address, right? Because I wanted everything to be the same. At the time, I was just trying to get everything the same, get an EIN, and then I could say, okay, the IRS agrees that I'm doing business in this name at this address. And if they try to send me anything that has the name backwards or some other thing, I say, well, that's not me. The federal government's agreed what my name is. That was way back then, right? But that's how we got to the fact that she's an organization. On the other one, we did it as an individual because she was going to be swearing to it. Yeah, I'll show you that in a second. But what did we do? We made the constitutional laws of the United States collateral. Rights, titles, and interests in the assets and personal property of secured party, Terry Lynn Wilson, owner of Wisconsin driver's license number, da-da-da-da-da. You own that number. You are the only one. That's your authentication for your identification, right? You got a piece of paper that says Terry Lynn Wilson on it. Well, how do we know which one it is? It's tied to your driver's license number. Not the driver's license, the number. Because that number, at least in Michigan, I had a driver's license. Didn't have one for a long time. Finally went to get a state ID, and they put the same number on it after telling me I was no longer in their system. But it had the same number as my old driver's license did. Right? So the number is tied to you, not to the license. And we asked for the proceeds to which secured interest attaches, saying that Terry Lynn Wilson, unmarried, incorporated, right? Everything had to do with her. This is the information that came off of the recording of her mortgage and the recording of her warranty deed. I just don't feel like reading this whole thing again. Going on to say, unless they executed a fraudulent UCC financing statement affidavit, which is what they have to do in Michigan, well, then they agreed that they were, unless they put it in, then they had to agree that we were correct. Right? If you want to stop and read it, go ahead. Okay, that was that one. And that was back on the 5/28. Well, about a month later, We got the idea. Well, let's do this. Right, so this would have been just before the last video I did. We'll make the state of Wisconsin and the courts the debtors. Right? Terry Lynn Wilson and her full legal name as an individual. Now, again, one thing you got to remember is you don't have a middle name, right? You have a first name, and if it's got more than one part, we'll put them in there. Mine's Robert Allen. I'd put Robert Allen where she has Terry Lynn. Da-da-da. Revocation of security agreement. Lender is an imposter. As the Lord lives, I, Terry Lynn Wilson, swear I am a victim of fraud and swindle. I revoke a certain security agreement entitled purchase money mortgage dated on a certain date, filed in a certain place. The lender has no legal standing to contract in the United States. The lender is an imposter defined by Uniform Commercial Code, da-da-da-da-da. Borrower is an unregistered legal fiction having no legal standing. The borrower name, instead of full legal name Terry Lynn Wilson, invalidates the security agreement. Because as we'll see, they don't use your full legal name on anything. The alleged security agreement, that's what the mortgage is. They can give it any title they want, but the very first line on these things says they're security agreements. And to be an agreement, well, more than one party would have to have signed. And they never sign them. That's why all your payments go to escrow accounts, because the parties that were supposed to have an agreement haven't come to one yet. So we're going to revoke it. Right, conspire against unalienable rights of Terry Lynn Wilson, one of the people of the United States, offending the Fourth Amendment of the Constitution of the United States. Rock County case is being used in an attempt to compel the state of Wisconsin to enforce this fraudulent security agreement. Right, I'm giving the state of Wisconsin a way out. Hey, these people did it to you too. You've been screwed. I asked the state of Wisconsin to affirm and acknowledge my exclusive rights, titles, and interests, real and personal property, incorporate my reference on instrument, render an account, provide equitable relief, and arrest the individuals responsible for the offenses against the United States. That was the idea. And non-UCC filing. All right, so those had been filed. And then we went down and we did a firm registration name. Because, well, we're just going to look at the assignment of mortgage as an example. Because this is tied to the deed of trust of the mortgage, right? Here it says, the mortgage executed by Terry L. Wilson, comma, an unmarried woman. That is a legal fiction that was made to replace Terry Lynn Wilson, to keep her name off of the documents. Now, Terry L. Wilson, an unmarried woman, just became the name of a business or something else that you were doing business under, because it's supposed to be you. But if you don't register that you're the owner of it, then you don't have any standing. And so this is the idea of claiming the fictitious name. You claim your name by getting a EIN from the IRS, doing business in your name. Robert Allen Rutluski. I don't care that it's uppercase. That's my name. That's my business. Right? That's just me doing business in my name. I don't have to register that with the county to say that I was doing business under an assumed name. But Terry L. Wilson, comma, an unmarried woman, that needs to be registered. And they had a form that looks like this, right? Registration of firm names. All right, County of Rock, Terry Lynn Wilson, owner. The post says that she's the owner of a firm doing business as Terry L. Wilson. Every jot and tittle, they used a period, put a period, they got a comma, use a comma, da-da-da, da-da-da, da-da-da. Where it's located at, when you get done, you'd circle that it's a sole trader, used it for real estate. When you're done, what's the return address? Well, that's just you and your full legal name. It's the same address. Return it to me. And then, and that the only persons interested financially in such business or using such name are the following. Name, Terry Lynn Wilson. Relationship to business. She's the sole owner. There is nobody else. Address, City of Egerton, Rock County, Wisconsin, United States. That is like her residence. Your residence is your place. And the place where Terry is a residence, as her residence, is the City of Egerton, Rock County, Wisconsin, United States. It's not her street address. It's her residence address. And they didn't specify, so I said, we will. Right? We already told them where to return the mail to. But we're trying to establish, my idea of doing this was to establish that she is in Rock County. That's her venue. If they try to take you to the County of Rock, which a lot of their paperwork would have on it, like here, County of Rock, State of Wisconsin, well, that's all King George's jurisdiction, which is sharing the same ground as we are. And we're going to say, well, no, we're not in yours. We're in ours. We're in the republic. You're in the democracy. This application hereby made, register such firm name with the Register of Deeds for purpose of complying with the law. Right? If you didn't do this, you didn't comply with the law. Print your name and sign it. This document was drafted by. Print your name. I told Terry she should sign her name above here, and I don't believe that she did, but because it says names of persons signing in any capacity must be typed or printed below their signature. Well, if we're going to type in the name here, then we should have put a signature there. But it is below her signature, which is up here. So, well, that's just the Johnson tittles. I don't know how deep we need to go to say we've covered everything, but I've learned that there's all sorts of things wrong, and it's all the details, and that's where the devil is. The devil is in the details, and we need to get them out. Well, she did that, and then she took it to the Register of Deeds, and she got it recorded. And then she took it over and put it into her court case. And this is the thing now they're calling a certified copy of Liz Pendens. So that's really cool. And well, there we are. And so the name that we used, again, was based on the thing on the deed of trust, not on the warranty deed, not on the thing that you think makes you own it, on the thing that people are saying this is the reason that we have the property is because you have a mortgage. And we're going to revoke the security agreement because Ditech Financial, well, they don't have anything to do with it anyways, but the lender never lent you any money. They didn't sign the agreement. They're not normally using their full legal name. They didn't use your full legal name. The whole thing is fraud, so just revoke it. But you can't revoke it until you say that you're Terry L. Wilson, an unmarried woman, because that's the name that's on there. And if you look at the deed of trust, or mortgage, it says that you are assigning all of your rights in the properties on the deed of trust to somebody else. So once you've done that, you don't have any frickin' say. Unless you go and revoke the damn deed of trust, the assignment. And that's what we did. What we're trying to do. Okay, I got to stop again one more time. Reload. Okay, so this is just to fill in some blanks a bit. This is the purchase money order, or purchase money mortgage for Terry. All right, this is where it was recorded under that number. So that was all the things I said that I was revoking under the non-UCC. It's all based on this information here, where it says in here that security instrument means this document. Right? It's the very first definition. So this is a security instrument. And then if you were to see, these are Wisconsin single family Fannie Mae, Freddie Mac uniform. You can go get a blank one online to play with, right? From Fannie Mae, Freddie Mac. And if you do that, you'll find them for each state. And well, if you put in like the word agreement and just start going through, you'll see it's used all over. And this agreement, this agreement, this agreement. Well, if it's an agreement, we both had to sign it. They didn't. Right? They didn't sign the last page. Borrower is Terry L. Wilson, an unmarried woman. Well, I thought it was Terry Lynn Wilson, right? Terry L. Wilson, an unmarried woman, didn't really exist until we claimed the name, but they put that on there. And this is the game they play. Compared to, right, now this is supposed to be the warranty deed, where it says Terry L. Wilson, comma, a single person. The other one said an unmarried woman. This says a single person, right? But this here is another legal fiction, a different legal fiction, not the same words. But this isn't causing the problem in court. The thing causing the problem in court is the fucking deed of trust, mortgage, because that's the thing that assigned this document and all the other things over to whomever it is that's saying that they are, entitled to it. So Terry L. Wilson, an unmarried woman, needed to be registered as the business, with Terry Lynn Wilson being the owner, so that Terry Lynn Wilson would have some standing in court to speak for Terry L. Wilson, an unmarried woman. Right? The attorney. Okay. And now just a little sidebar stuff. So in this thing, because Ditech was involved, I went on the Wisconsin Secretary of State site. You could, get a certificate on the company. So I did. Mary Ann McCoshin, Administrator, Division of Corporate Consumer Services, do certify that. And they're a foreign corporation or a foreign limited liability company authorized or registered to transact business in Wisconsin. Right? That doesn't help me, right? That isn't specific. It either is one or the other. They're not saying which one it is. But that's just the way they do it in the United States of America, which is the part that got me. United States of America, state of Wisconsin. Now, you do know that United States of America is a kingdom of King George, right? Raise your hands if you know that. You didn't know that? Well, you need to look at the Treaty of Peace. They're signed at Paris, September 3rd, 1783. Ratified and proclaimed by the Congress, United States. The Continental Congress, United States, Continent. Not United States of America, United States, 1784. Yada, yada, yada. Article 4, supplemented by convention. Article 2, whatever. Anyways, what did it say? We're getting all the things that the different articles. We just really, for today, care about what was in the preamble or, when the king was speaking. Because in the name of the most holy and undivided Trinity, it, having pleased divine providence to dispose the hearts of the most serene and most potent Prince George III, by the grace of God, King of Great Britain, France, and Ireland, Defender of the Faith, Duke of Brunswick and Luxembourg, Arch-Treasurer and Prince-Elector of the Holy Roman Empire, and CA, and of the United States of America. King George III is something over the United States of America. It's one of his kingdoms. The United States of America is not the United States of America, which is the very first article in the Articles of Confederation, March 1st, 1781. The style of the Confederacy shall be the United States of America. Right? It's not United States of America, it's the United States of America. Go look at your money. It says the United States of America on it. The Federal Reserve is in the Republic. Look at your passport. Or look at a passport. Just go look one up online, United States passport. Look, it'll have surname and then given name. All right, it's not using your full legal name for one thing, but on it, it says United States of America. It doesn't say the United States of America. So they got the wealth of the country in the Republic, and they got your ass over in the democracy. Under an assumed name or backwards name, or, that's the way Jews write. They write names backwards. They read from right to left. In fact, I heard a preacher talking not too long ago. Some video I was just skipping through. And he had said, that um, all the countries on one side of, this has been back in the old days, I'm not sure it's the same anymore because it's all been taken over, but back in the day, all the countries to the right, let's say, wrote from right to left. And all the countries to the left wrote from left to right. And they were the country that was in between both of them. And that's what they use, man. They write them both ways. Rosita's told me that, she lived in Lithuania. She had Jewish neighbors, and they would write backwards. So to them to see, if you say now that you have a surname and a given name, the proper way for them to write that would be Rytlewski, Robert Allen, not Robert Allen Rytlewski. I'm not a Jew. I want it Robert Allen Rytlewski. They're just going to have to learn that's the way I write my name. So, again, sidebar stuff, right? The United States of America was the thing that was created under the Articles of Confederation. Shall be, which is not the Treaty of Peace. 8 Stat 80, right? This is, what do they call those? That's the, I got a name for that. Oh, statutes at large. Right. So the statutes at large. It's a treaty. Hey, treaties, statutes, laws. Who do we go to? We got judicial officers sitting as bankruptcy judges that are actually judicial officers under Article 3 of the Constitution, which means things to do with treaties and such are their jurisdiction. So, United States of America is not the Republic. It's King George's kingdom. That's what the Constitution is about, is this union between King George's kingdom and the Republic, and we're going to share the land, and as long as you, United States of America, live by these rules, you can stay here. And so if you look in the Constitution about the president, it says, when he's elected properly, he'll be the President of United States of America. President of United States of America. The not being capitalized. If you look at the sign behind Trump, it says President of the United States. It's because he hasn't been properly elected, or he hasn't complied with the 6th article of the Constitution and taken an oath to support the Constitution, because the oath in Article 2 doesn't have the word support, but there is an oath that does, and it's in 1 Stat 23, Statutes at Large, 1 Stat 23, which was the very first law passed after the Constitution was ratified, that says in it, this is the oath that satisfies the 6th article of the Constitution. And if you haven't taken that oath, you don't have any constitutional authority. Not the president, not anybody who doesn't do it. If the president doesn't do it, he can't appoint anybody to hold an office. So all the people that say they're holding an office aren't. Right? They're just de facto. They're not de jure. Well, as it turns out, again, there's at least somebody that their authority, while they may not be an officer of the United States, they're acting as having authority under the Constitution, Article 3, which is where the laws of the United States are. And I say I'm in the United States. This is the reason they don't want to use your name. They don't want to say you're in the United States. Right? Because then you would be protected by the Constitution, even at a time of war. Which is, that's why the gold fringe flags are there. It's martial law. It has been since 1683. Go read the 2nd article of the Lieber Code. Once martial law has been declared, it takes a special proclamation or a treaty of peace to cancel it. And that crap ain't happened yet. Okay, I'll go grab a few more pieces of paper. We'll get into the nitty gritty. Okay, so here are a couple things that he had filed. This is the attorney for Ditech Financial, right? The attorney firm that hasn't filled out their paperwork with the State Bar of Wisconsin. There may be hell to pay for that. One of the things they're putting in is called a declaration of non-military service. They used to call it affidavit, non-military service. Now it's just called declaration. But the defendant is Terry L. Wilson, right? And I, the undersigned, declare that I am the plaintiff's attorney, right? This declaration is made for the purpose of obtaining a default judgment against the above named defendant. That's why we did it. I believe the defendant respondent is not an active duty military as this time because they didn't choose one. I obtained a certificate from the United States Department of Defense website showing that the defendant, Terry L. Wilson, is not on active duty status. This certificate is attached. I've attempted to determine, so hey, he picked 4 for Terry L. Wilson. And then he's the attorney, whatever, and he signed right there. We go down and look, and we see that, well, we don't know what social security number he may have used, and we don't know what birth date he used, but he only said Wilson Terry with no middle name, right? So it's not Terry Lynn Wilson, it's not Terry L. Wilson, it's nobody with this certificate number, and this is what he's saying is his proof that Terry, declaration of non-military service. Well, non-military service isn't a good thing because in Title 10, which is the United States Code, which is for the military, it says that all able-bodied men 18 to 45 are supposed to be in this thing called the is it the unregulated reserve? The unregulated, the militia. I don't remember the proper term. And everybody was supposed to have registered with selective services. All right. Selective service, right? But this would be saying that there's no record that you did with selective service. Which would mean, well, you're violating the federal law because you were supposed to have done this. There's nothing on here to indicate that, Terry's a female. This is the point. So they're just acting. They made females males with the paperwork this way. And they're saying Terry Wilson didn't do it. Well, unless somebody was to investigate further, we could just say, well, Terry Wilson then is in violation of federal law for not having registered with selective service. Terry Wilson doesn't have any rights, right? Terry Wilson is a lawless person. That's how they play that stuff. And he also put in, I got a lot of things over here. Right? Which one is it? Here. This one? And he also put in a Liz pendens. This is supposed to be a suit pending. Well, he filed this into the court case, and it shows up on like 7/5 the day he put in, but it just says Liz pendens. It doesn't say certified copy of Liz pendens. That one just says Liz pendens. Which is interesting. I mean, I guess we could call our stuff Liz pendens. But all it asks for on the form, this goes back to at the beginning of the form, it said you need to use this a particular style of form to put the paperwork in. And that's all this is. I had a generic one where we just put notice in here. And Terry put her address here, which they asked for, and then put her parcel number. Right? And this asks for a parcel number PIN, but this 026061014 is not her PIN number. That's her tax ID number. Her parcel number is a different style of number that they don't want you to put on here. In fact, they don't give you the whole number. It's like 0613983, 06-13-983 is the second half of a much longer number. if they gave you that entire number, that would establish your ownership on that particular lot, because that's all being done by the public land survey, right? The Midwest was all surveyed under the public land survey under the Northwest Ordinance. In fact, the rest of the country, after you know the Northwest Ordinance was put in, was done under a public land survey. Well, that isn't the same style of legal description they're using when they're taking your property. Like Lot 14, Block 10, Mallwood Estates, Township of Milton, County of Rock, State of Wisconsin. That is not a style from the public land survey. So you're not being given the land the same way that the land was given to the state by the federal government. Instead of you being given land under the public land survey, they created their own survey system, and they have this. Then they added a thing called a subdivision, which isn't in the public land survey system. It's not one of the units of land. They don't have subdivision, but they have it in these other ones. And so you've been put into this, the subdivision thing. Mallwood Estates is a subdivision. So they're not giving you the legal title on your warranty deed. Blah, 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 blah. So again, this is just one other paper that he had put in. I just want to point out, when he put it in, they didn't call it a certified copy of Liz Pendens. They just said Liz Pendens. On Terry's, when she put in her name registration forms, they called that. Where is it? Let's look at it. Liz Pendens, right there. That's the one he put in. That's all it says. When Terry put one in, a thing that was the name registration, they called it certified copy of Liz Pendens. I don't know what that means, but they're different. Okay. So I can close that one and that one. Okay, now what did he put into the court case here just very recently, like July 18th? So this is the letter it talked about in the stuff done July 18th. Dear Judge McCrory, this matter is set to come before the court on August 3rd, 2018 at 8:30 a.m. on the plaintiff's motion for summary judgment. The plaintiff has recently been made aware and has confirmed with the Wisconsin Department of Financial Institutions that the defendant, Terry L. Wilson, aka Terry Lynn Wilson, has filed the UCC financing statement naming as debtors the state of Wisconsin, judiciary courts of the state of Wisconsin, and counsel for the plaintiff in this matter, Gray and Associates, LLP. The defendant names Terry Lynn Wilson and the government of the United States each as secured party, and claims that said financing statement covers, amongst other things, the Constitution and laws of the United States as collateral. Her June 29, 2018 financing statement states an intent to revoke the subject mortgage contract dated October 21, 2016. I couldn't have said it any better myself. Yeah, that's all the shit that it says. Well, it isn't all of it, but you ain't lying. It does say those things. So he, first he tells the truth. Now he's going to, smear some poop on it. The threat of losing one's home to foreclosure is no doubt stressful, but Ms. Wilson has resorted to slander of title tactics that she knows or should know are false and frivolous and are being attempted solely for the purpose of harassing or maliciously injuring counsel for the plaintiff, Gray and Associates LLP, and or the state of Wisconsin and its court system. Wisconsin statute, blah, 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 blah. Accordingly, I have enclosed the plaintiff's petition. And proposed order to direct Wisconsin Department of Financing Institutions to expunge the defendant's May 28th and June 29th financing statements from the department's official records. All right, but that doesn't have any, well, yeah, I guess it does. It was filed. Cha-ching. So he must have done this electronically. Okay, got it. I'm understanding. So that was that part of the letter. Page 2. Finally, the plaintiff again would strongly encourage Miss Wilson to seek out the advice of a licensed Wisconsin attorney. She may choose to visit something or call the Wisconsin Bar Referral Service. Hey, well, we did better. We contacted them and we asked them for your frickin' paperwork, brother. Gray and Associates, because you're attempting to collect a debt. And if you don't have a debt collection letter and you want to do business as an LLP, you had to have registered per the Supreme Court of Wisconsin's rules. Okay, that one's done. That one's done. All right, that's those. Now, what else did he put in? Well, then he put in a petition. Right, filed 7/18, where he says the plaintiff, Ditech Financial LLC, by Gray and Associates LLP, by William S. Forshake, its attorneys, respectfully petitions the court as follows. That was interesting that they had added him into it now. Now they got him in his middle initial name. That the undersigned counsels for the plaintiff has confirmed that the defendant, Terry L. Wilson, a.k.a. Terry Lynn Wilson, has filed UCC financing statement with the Wisconsin Department of Institution Copies, which are attached here too as Exhibits A and B. He's even going to put our exhibits in for us as evidence. You know, he's basically saying what he had just said on a letter. Now he's doing it as a petition. Right? Who she named as secured parties, who she named as defendants, and she said that the Constitution and the laws of the United States are the collateral. That upon said financing statement dated June 29th, the defendant attempts to summarize an attempt to revoke the mortgage contract subject to this action. Yes, that the defendant knows or should know the contents of any part of the contents of said financing statement are false, a sham, or frivolous. No. Right? These are for the judge to decide. See, what's happening now is these guys have put it all in the judge's hands. That together with the financing statements, defendant's petition, order, show cause, hey, we did that, which is Exhibit C. So not only did they make exhibits out of our UCC filings, non-UCC filing, but also a petition for an order to show cause. The defendant knows or should know that their petition for order to show cause, together with financial statements, are without any reasonable basis in law or equity and cannot be supported by a good faith argument for an extension, modification, or reversal of existing law. And that's something. We're not trying to get the law reversed, modified, or extended, just enforced. Wherefore, plaintiff prays that an order be entered directing the Wisconsin Department of Financing Institutions to expunge said financing statement filed 28/2018, June 29, respectively, copies of which are attached from its official records. Proposed order. And they made sure to say it's just proposed. Upon the foregoing petition of William N. Forshag, and upon the files, records, and proceedings herein, it is hereby ordered that the Wisconsin Department of Financial Institutions shall fully expunge the defendant Terry L. Wilson, a.k.a. Terry Lynn Wilson's financing statement dated May 28, 2018, and naming Gray and Associates LLP a debtor from its official records, It is further ordered that the Wisconsin Department of Financing Institutions shall fully expunge the defendant Terry L. Wilson's, a.k.a. Terry Lynn Wilson's, financing statement dated June 29th from its official records. Now, normally when they do these things, they have something down here for the judge to sign that's all ready for them. All they need is the judge's signature. But, well, not only is it proposed, it doesn't say who they're expecting to sign it. And there's the letter again that they sent. Okay, well, what do you say to that? I don't really know. All I know is, again, he's the one who made exhibits. Exhibit B, Exhibit A, which here it is. I mean, this is, right? Exhibit A, he put it on there. And I got to ask Terry to send this to me. We got to read what all the scribbly stuff is, because, when we sent these there, they were like virgin clean. Now they got all sorts of scribbles on. I don't know how much is hers, how much is theirs. I wonder whose fax number that is, 414-224-1279. Maybe somebody faxed him a copy. Right? That's the file stamp of the court. Exhibit A. Well, that one's good. Hey, Exhibit B. See if this got all them scribbles on there. Well, they took the filing number off. Now, why would they be doing that? See, now they're removing, information from the form. But again, hey, it was filed with the court. Exhibit B. Okay, hang on a second again. Okay, so along the way, having created these UCC and non-UCC statements, and them having been filed with the state, right, there's the filing number, and it's with the Wisconsin Department of Financial Institutions, which is the filing office for UCCs according to the law. It's like, okay, well, it's been filed. Now I want to have it recorded in the county to say that it's been filed with the state. Well, Terry tried to take this down there, and they won't take it. In fact, she's tried more than once, and, she got letters written to her. So the first time she tried it, this was back in 2017, right? I didn't know Terry in 2017. I guess I met Terry in May of 2018. But she had tried this stuff before. And I think on that particular UCC financing statement, it was, not being done the same way. I'm sure it wasn't being done the same way. But she got a reply from the Register of Deeds. After further review of the financial statement addendum, financial statement amendment, that has been determined not suitable for recording. I have conferred with Rock County Corporate Counsel and been advised documents are not instruments authorized, recorded, right? Sandy wrote it. And I really didn't know. Terry may have told me that this had happened, but I didn't really pay attention to her, so we'll go try it again anyways. And she did. Well, then she got another letter. Right? Now, this one is from the Corporate Counsel. I guess that's the main thing I wanted to point out, right? The other one's from the Register of Deeds. Register of Deeds. This time it came from Corporate Counsel. Ms. Wilson, June 26, 2018. The UCC finance statement you submitted to the Register of Deeds for filing on June 25th has been forwarded to my attention. The purpose of the UCC finance statement is to allow a creditor to perfect security interest, personal property of a debtor. The UCC finance statement is not to be used as a defense to a pending foreclosure action. It is also not to be used to perfect security interest in your own property or to seek arrest warrants. I don't agree with that, but okay. After reviewing the documents you submitted, I have advised the Register of Deeds not to record it. Wisconsin statute. Record or cause to be recorded correctly and legibly all deeds, mortgages, maps, instruments, and writings authorized by law to be recorded. Let's just stop there. What you need to ask is, hey, what instruments and writings are you authorized to record by law? I need your index. And have them give it to you. And then pick one of those names and use it. Right? That's the Reader's Digest version of where this is headed. The documents you submitted are not authorized by law to be recorded, right? Because she's giving them just, a thing that says a financing statement on it. And the reason is, we'll see, is because it doesn't conform to their style of putting it in. Are not authorized by law to be recorded. You list the state of Wisconsin, the judiciary courts of the state of Wisconsin, the Gray and Associates as debtors on your UCC financial statement. Later in the same document, in the section where the appropriate collateral is to be described, you state the following: unless the debtor filed an executed fraudulent UCC financing statement affidavit, secured parties are victims of a simulated legal process under color of law, perpetrated by oath-bound individuals conspiring against rights from which equitable relief is demanded, and arrest warrants for offenses against the United States are issued and executed. There is no authority to record a document requiring a debtor to file a fraudulent document or to demand an arrest warrant. I'm returning the documents to your attention. Had they been accepted, they would have been filed on June 25th, 2018 at 8:30 a.m. Okay, on the other one he said, they said that he said, because now it's just, this comes from the Register of Deeds office, where she said, the submitted forms do not comply with the instructions for completion to be filed in this office. That's the real problem. They don't comply with the submitted forms, do not comply with the instructions. You mean they had instructions? Well, yes, they did. They had instructions and they put them on right on the document website, or on the Register of Deeds website under document preparation checklist, standard document format. If you wish to record legal documents affecting real estate, such as deeds, land contracts, mortgages, satisfactions, and assignments, you need to use a form which conforms to the Wisconsin Standard Document Format implemented September 1st, 1996. If your document does not conform, you may add a cover sheet to the front so it becomes the first page. Print or type the document title, return address, and tax ID number, and attach the cover sheet. That's all it's asking you to do. All right, so here's the cover sheet. Document title. So I believe notice is a document title. I believe acknowledgement's a document title. But I believe I could say to them, well, you're saying you can only do the ones authorized by law, then tell me which ones they are. And pick one and call it that. All right, put your name and return address in here, full legal name and address, and a parcel identification number, which, again, go look it up. Go look up what parcel identification number means. If that's the word they're using on this form, right, and this is a state form, then I guarantee you, if you put that into Google, something will come up. Let's see what it might say. Well, look at that. Parcel identification, number description. The parcel identification pin is used to identify and locate property for the purpose of taxation and assessment. It is also used to track property in various county offices. And it's got a municipality code, it's got a town, a range, a section, a quarter section, and hey, a number in the quarter section. I guess that would be the lot. The pin number appearing on these maps is a shortened version of the actual pin. A breakdown of the actual pin is as follows: MMM, TR, or TTRR, SSQQ, pound, pound, pound. If you had this complete number, they would say that you were a resident in that municipality. And what they're giving instead, because they gave Terry a thing they call a tax key number. So the section would be 06. The quarter, I guess that's the quarter section, would be like 13. And then this number in that section would be 983. But they're not giving you this. This is your PIN number, right? This is the PIN. That's what they asked for on the damn document, is your PIN number. But they don't give it to you. And so Terry called and said, well, what's my parcel identification number? They said, well, that's your tax key number. He said, well, that isn't the whole thing. No, that's your parcel. That is. That's your parcel identification number. Go ahead and use it. That's your number. Not that they'd lie to you. Right? That's just the way they've always done it. I mean, I'm sure that lady believes everything that she just told Terry. That's the thing with these people, is they believe what they're saying because they're doing it by custom. They're not following the law. The whole time they've been in the office, they've always done it this way. You start hearing them say that. I mean, you listen, they'll say, well, we've always done it this way. Well, that just means you've always been committing fraud. So that's kind of the story of Terry. That's where we are today, except for, well, there is one last thing. So let me go find it. Okay, so this is where we are today, starting tomorrow. So on Friday, Terry took this in with her exhibits, which were the fact that we had written to the state bar and the answer from the state bar about the registration of Gray & Associates, LLP. State of Wisconsin, Circuit Court, Rock County, Ditech Financial LLC versus Terry L. Wilson et al. Ex parte motion, remedial sanctions, case number 2018 CV 000136. I don't need to have the other party's permission to point out contempt of court. I'm just taking it directly to the judge. Principals of Gray & Associates LLC, my bad, attorney for Ditech Financial LLC, are in contempt of the Wisconsin Supreme Court's rules of professional conduct for attorneys, specifically SCR 20:5.7, limited liability legal practice, and from which Terry Lynn Wilson, the real party in interest, asked this court to impose remedial sanctions in accordance with Wisconsin Stat Chapter 785, contempt of court. Exhibit 1, 3 pages of this motion for remedial sanctions, evidence of recent reply, July 26, 2018, to written request for current registration information provided to State Bar Wisconsin in accordance with SCR 20:5.7, limited liability legal practice for Gray & Associates LLP, 16345 West Glendale Drive, New Berlin, Wisconsin, 53151. Response from State Bar Wisconsin evidence is contempt by Gray & Associates LLP of the Wisconsin Supreme Court by not registering in accordance with SCR 20:5.7, limited liability legal practice. Terry Lynn Wilson moves this court impose remedial sanctions upon Gray & Associates LLP principals and provide relief from false claims of Gray & Associates LLP and restore her rights, titles, and interests to or in the disputed ownership of the proceeds and property incorporated by reference in case 2018 CV 000136. And by the way, if Gray & Associates hadn't put it in, has not filed or ever filed this form, then Gray & Associates and any foreclosure they ever did is void. Because they never were an attorney. They could never collect a debt. Everything they did was contempt of court. Well, that's a horse of a different color, as they say. Okay, very cool. Just really quickly then, because that's what's going on in a judicial case. Excuse me. Which puts us up to ex parte motion remedial sanctions filed by Terry Wilson. You guys can follow along by yourself by just going to the Wisconsin Circuit Court Access and putting in, well, there's the name of the case, but just put in Wilson Terry. And follow along. Let's see what happens. Hey, they put the guy's full legal name in here. All right, now I want to just quickly go across to another one or talk about another one. Go across. Another one, which is happening in Georgia. Somebody sent me, which is a non-judicial foreclosure. And well, we'll just start with this form here. So folks got this in the mail. Now, this lady doesn't have a middle name, right? So it's just her first name, last name. And so the address, it's her proper case name at her address. But here, it says originally made by, and they're talking about a security agreement or security. Is that what they call it? Security deed, right. But this would have been her all caps. And it says that she made it to mortgage electronic registration system, which of course she didn't. Right? That may have been somebody else's nominee, but that isn't who she was dealing with. She was dealing with probably Southeast Mortgage of Georgia for, some sizable jack. And they got a filing number. Pay attention to that. So, well, Andrea Sharp. Sorry, Andrea, I thought I got all your names, and there it is. Please forgive me. Enclosed is a copy of a notice of sale submitted to the publisher of a legal newspaper. Okay, that's the main thing about this. But this is an attempt to collect a debt. Now, what do we know about attorney firms? A law, attorney firm, collecting a debt. Well, in Wisconsin, apparently, by the Supreme Court rules, or by the rules of Wisconsin, if you want to collect a debt, you either need to have a license or be a registered, licensed to practice law attorney, which is what it looks like they're claiming. But what does the Supreme Court say and the rules in Wisconsin about that in Wisconsin? Well, that you would have to have registered your limited liability company or as an attorney, limited liability with the state bar of Georgia in this case. That's if the rules say that. So go find the Supreme Court rules for your state. Look for limited liability company. I bet you it's under Section 5.7. I'm not saying that it's uniform. I'm saying that I bet you it's in Section 5, probably 0.7. Blah, 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 da, 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 da. But this is interesting. This is a court case number. Right? I don't know where it is because they went down to the county and to try to find it and didn't find it. But I wonder if it's in bankruptcy court. Because one of the things it says is they will have to wait. We will assist you. And we'll see if it's on the next page. Yeah, the sale will be conducted subject to confirmation the sale is not prohibited under U.S. Bankruptcy Code. So is this some kind of thing going on in bankruptcy to find out if it's okay to foreclose on them? They had to open a case to ask the question. Not really sure yet. Under the virtue and power sale contained in a certain security deed dated some date. So it says all caps, right, to mortgage electronic registration system, certain tract of land, right, that all that tract or parcel of land lying in the land lot, that's what you want, the land lot of some district and section of Douglas County, Georgia. And being not a land lot, but a lot of some freaking subdivision. Right? This subdivision, this is in the state's own version of surveying. What you want is you want to be tied to this up here. This is this very first part here. Right? This is the public land survey. And so, you want to have your name on this land lot. Wherever that is, you want that thing to say it's yours. All right, go find it. The notice of intention to collect attorney's fees has been given as provided by law to the best of the undersigned's knowledge. The person's in possession of the property is, and this had her all caps name. So this is written to proper case, and now ever since we've been talking about all caps, this is all caps Andrea. The property being commonly known as, where it is property of, I think it was all caps. Yada, 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 yada. Now this is the really interesting part. So at the last page, it says, Albertelli Law, attorney for Stearns Lending, LLC, as attorney in fact for all caps. In other words, Alberti Law, attorney for Stearns, LLC, right? That's like the name of a legal fiction, is claiming to be, all caps, attorney in fact. Right? Not attorney in law, attorney in fact. What's an attorney in fact? It's a fiduciary. They can't give you legal advice, but they can sign papers for you. But they're a fiduciary. Well, so they would be like your, if you were doing a UCC filing, that would make them your debtor. If you're all caps, which you are, because that's just your full legal name being used in all caps as a business instead of you in personam, then they owe you a debt. So I told Andrea, well, you need to go to the IRS website, watch the video I did back in December called EIN and SSN in your legal name, or in your name, I think it is. And do it as a sole proprietor so that you'll get back from them a piece of paper that says that this all caps, because again, she didn't have a middle name, so they couldn't put a middle initial. They may have done it differently if she had a middle initial, but she didn't, so they just made her all caps name. Go claim it, and now you own it, and now you can say, okay, well, you're saying that you're working for me, that you're my attorney in fact, I'm going to tell you what to do. Make him your debtor. Put him on a UCC filing. But beyond that, we got to figure out where the hell this court case is. And I'm just saying, well, they're talking about, something to do with bankruptcy. Then it could have something to do with bankruptcy. And as it turns out, the bankruptcy judges are judicial officers of the United States in accordance with Article 3 of the Constitution. And that's going to be a nail in their coffin if we get them boys to talk. I did a video some time ago now, probably last summer. A lady that was in bankruptcy here in Kalamazoo, I think she's from Kalamazoo area, but it was Western District. And she said when she went to court that there were two placards on the wall. One said United States District Court, the other one said Bankruptcy Court. Right? Well, you want the United States District Court because that's the District Court of the United States. And I don't believe we have to go to the clerk, but we may be going to the clerk. But I'm going to write to the judge's staff in his chambers, because I want him to issue an arrest warrant. I'm not trying to go to bankruptcy court. I'm trying to go to the United States District Court, get an arrest warrant issued, or whatever else it happens to be. Anything under Article 3 of the Constitution, which means, the Constitution, the laws of the United States, equity, law, ambassadors, and. Goes on and on and on. So that's where we're at. It's I think I had a couple other pieces of paper here to look at, though. What else was there that she had? Okay, assignment, right? Where they're saying that it was assigned to mortgage electronic registration, right? That all caps assigned it to them. So they keep saying these things. But what the title insurance says, Schedule A to her title insurance, which is really handy if you can find your title insurance to take a look at. It says the name of the assured, that was her and her full legal name, and that she has fee simple title, right? So go claim that name and go talk to your title insurance company and say, hey, I got fee simple title. You need to get your ass down to the courthouse and protect me. And they gave the same lot. But here in Schedule B, which would be things to make it excluded why she has, things that aren't covered, they say the security deed was made between her and Southeast Mortgage of Georgia Incorporated in the original principal amount of. They don't say it was made to Mears. Right? So this is a title insurance claim. It's like, hey, these people are claiming I have a contract with mortgage electronic registration system. No, if I had one, it was with Southeast Mortgage of Georgia Incorporated, but they didn't sign the frickin' paperwork. So I'm revoking the damn security deed. I revoke the deed. Claim the name, revoke the deed. File it into the record. Things that we're working on. Right? I say revoke it on a non-UCC filing as a UCC financing statement. Get that, put whatever you need to put on the front as a notice or whatever, and go file it into the county, referencing your interest in the property, whatever it is that we're using for the identification of the property, be it the parcel code or tax ID number, whatever that is that you could use. And just claim the damn stuff. Right? Because you're insured. I mean, this one says here, the name of the assured is Andrea and her all caps name, and that she has fee simple title. Except for these things. And if we were to look at these, we'd find out, well, there ain't much there anyways. But the main one is, well, to Southeast Mortgage of Georgia Incorporated. That's not who they're saying it is. It's that she had executed a security deed to mortgage electronic registration system. And that is not what happened. I'm afraid they are incorrect. And what else was there? Title insurance assignment? I guess that was it. So, Andre, I hope you don't mind I used your name. Please forgive me. I try not to do that anymore, but I had done it in the past. Terry told me I could use her stuff, so it's like, it makes it so much easier. Yeah, go ahead and use it, right? It's for the common good. There's really nothing to hide. You don't have any hidden information anyways. So all this stuff has happened now, and it's all in, and we're up to see what's going to happen after 7/20/2018 in a court case in Rock County, case number 2018 CV000136. Ditech Financial, LLC versus Terry L. Wilson. Et al. I should say, she also did another assumed name or firm registration, just as Terry L. Wilson. Now, that wasn't meant to be that way. It should have been Terry L. Wilson, unmarried woman. Because she did, we went and did it again. But, that's who they're saying it is. They just keep saying Terry L. Wilson. So, right? She needs an assumed name certificate. Where Andrea, they're using her name. She doesn't need an assumed name certificate. What she needs is just to claim her name from the IRS and say, well, that's me. I have the EIN number for it. And since you say that you're my fiduciary, I want you to rescind the deed of trust or the security deed and get me back my property. attorney-in-fact, because the attorney-in-fact says he's working for you. I should show that one more time, because it's like that on, it isn't just hers, right? If you're in Georgia or you're in a non-judicial state, but I guess I should just say Georgia because that's the only one I'm really sure of. No, that's not the one I want. Come on, Bob. Just a second. Right in here. In the notice of sale paperwork that they send you. Right, this thing that they're claiming that they have filed, right, because this whole letter is to say, hey, we filed something, a notice of sale under power. And if you were to look at these in the newspaper, it'll say the same thing, that somebody is doing it as an attorney-in-fact. In fact, I think if I just do this should be quicker. Just to show you that they are using it in, what they consider to be, I don't consider them newspapers necessarily, but right, notice of sale under power, state of. Gwinnett Daily Post, from Darren C. Woodward, right? See, now this case, Darren had a middle initial, so they used his middle initial name, apparently, on the paperwork. And it goes on and on and on, and then finally it says here that Albert Law, attorney for Home Point Financial Corporation, as attorney-in-fact for David C. Woodward. They're acting like they're your frickin' they're acting like they are your attorney-in-fact. So, in this case, you have to go claim David C. Woodward, if that's what or Darren C. Woodward. You have to go claim that as a fictitious name. Do whatever you need to do to claim it. With you, Darren, let's say it's Charles Woodward, being the owner. Darren C. Woodward's a fiction. It's the name of a business you decided to do business under, but the owner is Darren Charles Woodward. And now you have a certificate from the county that they agree that that's you doing business under that name. And so now you would have standing to say something about what the frick is going on with Darren C. Woodward and his property. Amen. Okay, I'm going to leave it at that. Have a great day, and I hope you found it useful information. We'll see what we can do with it. See you.